I'm here today to talk about major reasons for the refusal of the US visas. Many people are applying US visas and they get denied. So what are the causes or major causes, major reasons for the visa refusals, or we call the visa denials? So many questions. But the types of visas I'm talking today are what I call non-immigrant visas, because there are major two types of visas. In case you do not know, there are non-immigrant visas and immigrant visas. Immigrant visas are the visas you come here to the United States and become immigrant. And by immigrant, we mean you become a permanent resident. You get green card. So if you come here and direct, you come from day one, you come as green card holder by winning green card lottery, or you come under the family visa. Those are we call immigrant visas. But I'm talking about non-immigrant visas, the visas you come here on a temporary basis. Whether you come here as a student, whether you come here as a tourist, whether you come here for a meeting, conference, you come here for medical reasons, whether you come here to work on temporarily under H1 visa, you come here as a scholar like Fulbright J1 visas. So all those kind of visas, you come here for a specified time. So those we call non-immigrant visas. And the majority of you who are applying for the visas are applying for the non-immigrant visas. So there are so many questions people are having on visa refusals or denied for the visa. What are the major reasons? So I will give just the reasons, and I will explain in detail one major reason majority of you are usual falling into that reason, and that is the reason I'll go to explain in detail in this video. Welcome everyone, this is Ernest Boniface Makulilo, EBM, talking to you from my home office here in Belton, Missouri, United States of America. So in case today is your first time to come across to my YouTube channel, please remember to subscribe to my YouTube channel, but don't forget to follow me on Instagram, on Twitter, on Facebook, wherever you can be able to follow me, but share these particular videos. I make videos in regard to the immigration, in regard to the scholarships, in regard to writing books, self-publishing, and so many other things we can do in order to succeed. So let's go straight back to the main part of this particular topic. So, before I go to start, these are the major visa refusals, or the major reasons why someone can be denied the visas. But the point I want to explain to people is, if you are rejected or denied the visa, is that the end of it? Can you be able to reapply another time? Can you be able to appeal? So those also depends on the type of visas, and I will explain in detail when I'm going to explain the reason or major reasons for the visa refusal. So there are 5 main reasons, and I will explain you one in detail. The first one we call the incomplete application, or failure to submit the all supported documents. So you can be denied because of not submitting enough documents. I'm giving an example. If you are a student, you are coming here under F1 visa, and you say you are coming here, but you don't have what we call, for instance, document like I-20, or you don't have service, you haven't paid for that, or you are supposed to have the admission letter, you don't submit the admission letter, you don't have bank statement, so you can be refused under incomplete application. Either you submitted the application was not complete, or you did the complete application but you didn't submit all supporting documents which are required. There are documents which are required, there are documents which are extra, but if you don't submit the required documents, you can be refused the visa based on what we call section 221 subsection G, incomplete application or supporting document. So in case you get refused the visa has been denied based on the Immigration National Act section 221 subsection G, which means a visa has been denied under that section. It means that the consular officer did not have all the information required to determine if you are eligible to receive that visa. So in that situation, you'll be required to there are two things. You can go and get the documents. Sometimes they might say that, okay, we are not going to refuse it automatically, but bring this document and then we can process you. But sometimes they can refuse completely. If you want, you can go and do another application and do the new application with application fee and get another appointment and come to the visa. So that is number one reason for the rejection, which is also common. Other the reasons which we call the visa qualifications and immigrant intent, which is called the section 214 subsection B. This is the biggest one, and I'm going to explain in detail about this one, but let me mention the rest and then I'll come back to this one because everybody is following this one. Remember, the keyword is you have failed to qualify for the visa and to prove you have what we call the immigration intent, that you intend to become, immigrant intent, you intend to become immigrant here. That means you come here, you are not going back to your home country, and I'm going to explain in detail about that one. The other one is section 212 subsection 8 subsection 4, which is a public charge which has been introduced. But another one we call is fraud and misinterpretation. If you come with a fake document, you misinterpreted someone, that can be reason. Then there is another reason, unlawful presence in the United States. This is if you have lived in the United States before, you lived beyond your visa, you became illegal, or you were supposed to be a student or to come here for visiting visa for this specified time, then you stayed extended period of time, so it was unlawful presence in the United States, so that can cause the visa denial. So let me go to explain about the this section, the section 214 subsection B, which we call this one. First of all, people want to know what does that mean? If you are refused into this visa category, it means one of these two things. Either your application and interview process, when you were interviewing, they did not sufficiently demonstrate that to the consular officer that you qualify to get the non-immigrant visa under the reason you applied. That will be number one. But number two, the reason will be, so the number one is you didn't qualify. Either the form itself, how you filled, the document submitted, you didn't qualify. For instance, I'm giving an example. You applied to become a student, and when you applied to become a student, you were supposed to have a bank statement of maybe $20,000, and then the bank statement is not having that money, or it has that money, but it is from your friend. So the point is, it doesn't show exactly if you really coming to study, because the bank statement has a lot of questions. So number one reason can be, it means that you did not sufficiently demonstrate to the consular officer that you qualify for the non-immigrant visa category you applied for, whether it is a visiting visa, whether it's a business, whether it is student visa, whether it is J1 exchange visitor visa, whether it is H1 visa, whatever it is. That can be one of the interpretation of the section 214B. But another aspect of that section is, that means you did not overcome the presumption of immigrant intent required by the law. Which means you have failed to demonstrate that you have strong ties to your country. It means you don't have any reason why, after arriving into the United States, you'll come back to your home country. What will compel you? What will force you to come to your home country? So you did not overcome the presumption, because once you go there, the assumption is you want to go there as a student or a tourist, but the intent might be you want to become immigrant, you want to become permanent resident. Down the road, you want to become a US citizen. So you have failed to show that that is not your intention. You haven't demonstrated that you have strong ties to your home country that will compel you to come back to leave the United States once your visa has, the time for the visa or the reason to be in the United States has ended, to come back to your home country. So, what things are they considering that this will make you as a strong ties to your home country? So, the ties, this one are a few things which they believe there are some aspect of your life which on one or another they can bind you to your home country. And the strong ties can vary from one country to another country, from one city to another city, from one person to another person. So what I'm going to mention here, these are not the only one. These are some of those items. For instance, it can be your job. What kind of then when it comes to job, what kind of job do you have? Someone can be a student. Maybe you are a second-year student, you are asking for a tourist visa. Yes, you have a ties because you are currently a student. You don't intend to quit your studies and leave and go to another country. That can be something you can show up. Your job, again, it depends what type of job you have. Is it a temporary job? How much that job gives you is salary, or you have a business, is that a registered business? How much income do you get? How much profit do you get? So they are looking all those factors, but it's not like because you have a job automatically you are going to be given. Do you have a letter from your employer that maybe you are going there during the holiday, that you have maybe annual leave, you want to go there and your job is still there? If you're a student, you need to have a letter, at least from the, apart from ID, just to show that you are outstanding student and you are going there, you'll come back to finish your studies. So things can be your job, your home, you have assets, you have a home, you have farms, you have other assets, you have vehicle, you have whatever. So what assets do you have? Some people, the other thing they look at is the relationships with the family and the friends. How are you connected? What ties do you have with your family? So sometimes they might look like, okay, maybe you are not married, you don't have a child, maybe you are the only child at home. So they are looking all those factors, but it doesn't mean that if you are married and if you have children, that means it's a guarantee to be able to be given the visa. No, they are going to look all those kind of aspects, because you can be having, you cannot say, oh, because I have parents, I have father and mother, so I cannot live in America. Yes, I'm US citizen, my parents live in Africa. That is not the only reason. So it's case by case, situation by situation. It's different when you say, I'm the one who is in charge of taking care of my mother or my father who is having maybe this kind of disease. So I'm going there for maybe conference and I have to come back because I'm the only person taking care, and these are the hospital taking care of my mother during this time. So you can have those kind of convincing documents. While conducting visa interviews, the consular officers look at each application individually and consider each applicant's circumstances, travel plans, financial resources, ties outside of the United States. That will ensure that applicants will be here on the temporary basis, and after finishing, you'll go back to your home country. But if you are going to be denied the visa, maybe because of this section 214, that means you don't have enough. Either you fail to demonstrate that to the consul that you qualify, or presumption of immigrant intent, you failed to show all those kind of things. Are those is that a reason to be refused? Is that the refusal permanent? Can you go and get again to that one? So number one, there is no appeal into the US visa processes. So if they deny the visa, there is no appeal. What you can do, so what we say that the question is the refusal of the visa under section 214B permanent? The answer is no. The refusal or ineligibility under that section for the specific application is just applicable on that specific application, and once the decision is done, that application is closed. The consular is not going to take any further action based on that case. So there is no appeal. So if you have any additional information or you have significant changes on your circumstances, maybe now you have a very good job, now you have become member of parliament, that means you have a reason why you'll go back to your home country, you can reapply for the visa. And once you reapply, that means you are completing a new application, you pay new application fee, you schedule new visa interview, and your application will be going to be discussed as a new application without considering the previous application why you were denied. Unless otherwise it is based on the criminal, they look about the criminal, they look about if you, everything will be going to be looked at as different. So this is example, I'm going to read one of the example of the letter of someone who has been denied the visa application. This is a general letter. It will be given if you have been denied. This was denied because of the section 214B, which is the most common reason. And this letter is going to be given to majority of you. So it says, dear applicant, thank you for your recent non-immigrant visa application. After a careful evaluation of the facts gathered at your application and the materials you submitted in support, regrettably, your visa has been refused under section 214, subsection B of the Immigration and Nationality Act. We adjudicate visitors visa based on applicable United States immigration law, which says that an applicant is presumed to be an intending immigrant to the United States until he or she can prove otherwise to the satisfaction of the interviewing consular officer. Applicant must show that the consular officer that they have sufficient family, financial, employment, or other ties to their country of residence in order to be entitled to non-immigrant status and to ensure that they will leave the United States upon completion of authorized temporary stay. Finally, they must convince the consular officer that they will not need or desire to seek unauthorized employment. Foreign nationals may not work in the United States while on the visitor visa, except on rare cases where the visa specifically permits him also to do that. An applicant for an F1 visa student must include or must demonstrate that has accepted to ensure that full course of study under Department of Homeland Security approved institution as evidenced by the presentation of the Form I-20 A and B and the electronic verification of the document through ISSO service. Secondly, has sufficient funds to cover the first year of study and access to the sufficient funds to cover the subsequent years. Has another one, has a minimum preparation for the study course and sufficient knowledge of English to pursue the intended study and things of that nature. So has a present intent to leave the United States at the conclusion of the studies, if that is for the students. Unfortunately, you are not presented sufficient or convincing evidence to demonstrate that you meet the above criteria. Today's decision cannot be appealed, but please know that a supervising officer reviews all cases and that are refusals. You are welcome to reapply for a student visa, but we only recommend that you do so if you have a significant change in your personal circumstances, or if you have new information that was not presented to the consular officer during the previous interview. The visa application fee is not refundable, regardless of whether or not the visa is issued. Sincerely, the consular officer. So that is the reason why you can be denied the visa. So I'm going to put the link on the visa refusal on how these work and everything. So thank you everybody and nice day. Remember to subscribe. This is EBM Ernest Bovas Makulilo out.